Among Oregonians, some of the least prepared to do an inquiry into what they're trading in exchange for their personal information are K-12 students. Schools increasingly contract with third parties to take advantage of online data storage, productivity software, or cloud computing services. Some services, such as Class Dojo, are explicitly designed to track student behavior over time. When we went to school, our permanent records were stored in a filing cabinet in the administration's office. Not so anymore. They're stored in the cloud, whatever that means. These services may greatly reduce school costs and may increase the quality of student education, especially in poorer districts where students may not have access to technology at home. But they offer increased risks for student privacy if student data is not carefully handled. To use another example, Google, whose lovely free pen I have with me, gives free or reduced cost laptops known as Chromebooks to schools around the country. Schools use a school-branded version of Gmail and Google Apps for free as part of the educational experience. But Google is extraordinarily cagey about what information they collect from students and how they use it. Google states that they don't use student information to target ads to those students, but that's just about all they say. They appear to be collecting student data in the school context and combining it with data collected outside the school, while students are logged on to their student account using not school services, other Google services. Google is completely opaque with what happens to the data collected outside the school context when combined with data collected in the school context. And after graduation, we really have no idea what happens to that data. We at the Electronic Frontier Foundation have been trying for months to get a straight answer out of Google, and so far we have failed. Existing federal legislation that traditionally has protected student privacy, like the Family Educational Rights and Privacy Act, also known as FERPA, is unclear how to treat digital records. FERPA was passed in 1974 and did not envision things like the Chromebook or Class Dojo. New state laws, however, could provide meaningful privacy protection in the online world. In California, this session we passed SOPIPA, a statute that will go into effect in January of 2016. SOPIPA will place several restrictions on companies that offer online sites and mobile apps targeted primarily to K-12 school purposes. SOPIPA will ban targeted advertising and prevent the development of student profiles. This is precisely the question that Google is unwilling to answer, or appears to be unwilling to answer, to at least the EFF. SOPIPA will also prevent the sale of student information and the disclosure of personally identifiable information about students. With services already gearing up to comply with SOPIPA in California, now is an excellent time for Oregon to address the same issue, and student privacy and school privacy in general. SOPIPA would also require educational services to maintain reasonable security standards rather than, and it uses the term reasonable, and I think that's important because rather than try to specify individual or specific security standards that would surely be outdated even before the statute went into effect, it gives an industry standard reasonable security practice level. And most importantly, unlike FERPA, which only created liability for the school, SOPIPA would create liability directly for the service provider that misuses the information. And this is critical. Under the current scheme, if Google creates profiles of students and then targets ads at them, that would be a FERPA violation. But it would be the school that would be on the hook for that violation, and Google would get off scot-free. And that does not exactly create an atmosphere where districts are incentivized to apply rigorous oversight to their service providers, especially rural districts that don't have particularly much in-house technical expertise. And while SOPIPA does not create a private right of action, it would allow enforcement against the service provider by public agencies as well as the Attorney General's office. And that brings me to my final point. While there is definitely a need for additional statutory protections and transparency, Oregon can use its existing powers to protect its consumers. As the Attorney General said, Oregonians should not have to give up their rights just by virtue of participating in this modern world. We don't expect our cars to be telling advertisers which doctors we see. We don't expect our students' school-provided email to be creating a permanent record of their behavior that can be monetized at a later date. Fraudulent, unfair, and misleading conduct online, as the Attorney General said, is just as fraudulent, just as unfair, and just as misleading as that same conduct offline. And we deserve to know what our technology providers, the providers that we depend on for our modern everyday lives, know about us and who they're telling about it.